So, Mr. Brown, have you and Mr. Denham and Miss Cohen worked out what to do?
My lords, my lady, we have a proposal for the court in relation to the powers argument. That question, whether the Upper Tribunal had the power to remit everything if it had only allowed the asylum appeal, hasn't yet been argued by either of us.
No.
I accept, and I brought in mind an observation that my lady made this morning, that the Upper Tribunal didn't purport to allow only one part of the appeal, but remit the entirety of the matter to the First Tier Tribunal. The question whether the Upper Tribunal had that power is an interesting matter that Mr. Denham and Ms. Cohen and I have spilled much ink on, provided that it would remain open to the Secretary of State to advance that argument for the future. Then my instructions are not to seek to pursue it this afternoon on the basis that, in essence, the matter has been passed over, and the latter part of this hearing has dealt with the substance of the First Tier Tribunal's decision, and the Secretary of State is mindful of the time that would involve and the time that this matter has now occupied this court and others.
Well, you've been reading our minds, Mr. Brown, because we've been talking about this outside for a few minutes, and we think that accords with what the view where we come to. Are you happy with that?
Yes.
You think so? Right. So where do we go from here? Is that you finished?
I think that means that there's the Secretary of State.
Well, thank you very much. So that what's left is.
Well, there was.
Oh, there's your point.
There was one point, and I think
has a point.
I'm sorry about this. You need to go back to Judge Smith's judgment in the core bundle. And it relates to what seemed to be a separate PSG or particular social group point. And there was an argument, I think, when it was before him, as to whether that was in terms of the statutory provision, a new point, and therefore potentially something which could not be adjudicated upon. And I think he directed that when the matter went back to the FTT, the Secretary of State would make his or her position known, and it would be dealt with. And in particular, it was an issue as to whether the Secretary of State would consent to the matter being dealt with, if it was a new point. Have I understood correctly?
My Lord, yes, I believe so, and I think that...
And what happened, because the Judge Davey didn't deal with it?
Yes, I think that was one of the bases on which the appellant sought to appeal the Judge Davies' decision.
So the Secretary of State didn't consent? Was the new point argued before Judge Davey?
I believe that it was.
Right, without wishing to give evidence on the point, in terms of the hearing before Upper Tribunal Judge Smith, that point was raised.
Yes.
But I think the issue, and yes, I have to, obviously Judge Davey does not grapple with that in the detail.
Well, was it dealt with in front of him?
No, but I think the issue, and that's because the substance of the matter had been raised, and the latest position from the Upper Tribunal, a case called Ayoola, A-Y-O-O-L-A, considers that where the substance of the matter has been raised, that is sufficient.
So the new point jurisdiction is not engaged?
Yeah, so
does the Secretary of State accept that?
My Lord, I don't have instructions on that now.
Okay, sorry.
No, then we'll leave it there. Thank you very much. Thank you, Mr. Brown. So, Ms. Cohen, you're going to reply, are you?
Yeah.
And will that then finish, or is Mr. Denham going to sweep up?
My Lord, I think that will then finish. I have nothing to add.
Thank you. Right, Ms. Cohen.
I'm grateful. So I just want to take my Lord and Ladyship's back to GS India, if I may.
GS India, yes, okay. Here it is in front of me right now.
Sorry, my Lord.
I've got it, as it happens, open in front of me.
131.
131, so that's towards the end. Right. Yeah.
And so we're back at this dichotomy, if you like, between Article 3 and Article 8.
Yeah.
So we see first sentence, paragraph 85. It is common ground when in cases where the claimant resists removal to another state on health grounds. But failure under Article 3 does not necessarily entail failure under Article 8. So that much is clear. And it's worth, in my submission, just reading what was said in J.A. Ivory case. So there is no fixed relationship between Article 3 and Article 8. Typically, a finding of a violation of the former may make a decision on the latter unless it's
Yes.
the latter is not simply, a more accessible version of the former. Each has to be approached and applied on its own time. And then at paragraph 86, we have that sentence which states or provides, if the Article 3 claim fails, as I would hold it as here, Article 8 cannot prosper without some separate or additional factual element which brings the case within the Article 8 paradigm. And I think my submission is more that it's easy for that sentence to be taken out of context, and that it is required, if one is placing any reliance on that sentence, to be read with paragraph 5 and paragraph 86, 87. And so, in my submission, the correct position, as we see later on, paragraph 86, the only cases I can foresee where the absence of adequate medical treatment in the country to which a person is to be deported will be relevant is where it is an additional factor. So where it goes to that overall assessment, whether there are very significant obstacles or whether it is disproportionate to remove the person. An additional factor to be weighed in the balance with other factors. In that case, the appellant had established firm family ties, there was availability of continuing medical treatment, coupled with dependence on family for support. And so we begin to see the additional factors that may come into play in a separate assessment under Article 8. That's really the only point I wanted to make about that.
But except if you read on, that conclusion would not involve a comparison between medical facilities here and those in Zimbabwe.
No, because what's being said there is that if you are talking solely about the medical condition, the state of the law is such that if that is all that is at play in medical condition, with nothing else, no private life that is worthy of respectful engagement under Article 8, then on that basis you are purely just looking at the availability of treatment in the host country and the availability of treatment from return. And that is what, in a manner of speaking, is being deprecated.
Okay.
And that's the,
So what submission do you make in reply
in
based
reply,
on that?
My submission is that the position remains that Article 3 and Article 8 require very separate assessments. Require very separate assessments.
Yes, thank you.
And that sentence in paragraph 86, first sentence cannot be taken in isolation. It must be read with paragraph 85.
Okay, thank you.
That brings me to the stigma of societal discrimination.
Yes.
That was not a standalone Article 3 claim here. That is a factor that goes to the various factors that are to be considered in terms of the likely circumstances of return. So it goes to Article 3 in terms of what the circumstances will be for the appellant. It goes to whether there are very significant obstacles, but it also goes to the overall proportionality of the appellant's removal.
Under which article?
I'm sorry.
Under which article?
In principle, under both.
Well, proportionality
point
only
is that
arises
it
under
comes-
Article 8.
It only
Sorry.
rises under Article 8, yes, of course. So it's one of the central features of Mr. Brown's argument is that looking at the First Tier Tribunal judge's judgment, the strands are all mixed up, if I can use that phrase. And on societal discrimination, it's woven in to the argument without, he says, and I'm paraphrasing, with making it impossible to discern which right is being considered. And if you're right that if you're right, as you seem to be right, the Article 3 and Article 8 require separate assessments. That's your point based on GS India. How is that consistent? How is the First Tier Tribunal's approach consistent with that?
I mean, I have to accept that the Judge Daly does not grapple with each article cleanly. I mean, that is apparent from the fate of the determination. What the judge is very much grappling with, in my submission, is the evidence that he clearly found overwhelming in this case, and is, if you like, considering the articles through that lens rather than ideally the other way around. That's perhaps where we see the overlapping elements.
We can see that he refers to a considerable number of aspects of the evidence, some of the evidence you took us to this morning. But where does the point is you've got to see his reasons, and the argument is you can't see the reasons on the different strands of the case.
No, I think my responsible submission on that would be that if you're not with me on the Article 3 point, and that the conclusion is that is unsustainable, that still requires an assessment to be made of Judge Davies' decision under Article 8. So, very significant obstacles and the proportionality of the opponent.
So what does that mean in terms of this appeal? If we're against you on Article 3, what then?
Well, then there would be a finding that there was an error on both sides, and there would be remittal to the first year. Might I just have 1 minute? But of course, as I'm reminded, it would also mean that the Article 8 decision by Judge Davey would be required to be upheld.
Did you say upheld?
Yeah, the Article 8 aspect of the decision. If your lordship and ladyship are with me, that is clearly a sustainable decision on the legal test under Article 8 and the evidence before the judge and the reasons that he does give, then that aspect of the decision would be upheld.
If presumably we could see that the judge had reasoned it in a freestanding way, a way which was not tainted by matters which did give rise to errors of law. Is that fair?
I'm sorry, is that... So I wasn't clear on the question.
Well, you're saying that we should still uphold the decision on the human rights aspect by reference to Article 8.
Yes.
But to do that, we would have to be satisfied that the judge expressed reasons under Article 8 which applied the law and were freestanding. In other words, not tainted by any other error of law. For example, under Article 3.
Yes. No, I accept that. Well, I think if we... without necessarily going back to the determination, unless that would assist, we know that there is very clear reference to Dr. Day's report.
Oh yes, to the evidence.
Yes, the very significant obstacles that would face the appellant on return, the fact that he would not be able to tell his family in order for the purpose of accessing any support or treatment, even if that treatment was available. And then, of course, we also have that in that paragraph 18, that overall cumulative assessment of the circumstances that the appellant would face on return, and the public interest question that the judge grappled with. We say taking that together, that is a sustainable decision on Article 8 terms at the very least.
Thank you.
I'm grateful. Just to perhaps mop up 1 or 2 points.
Yes.
I think your lordship asked about the question of irreversibility, which is obviously what that first limb, in terms of how...
Irreversibility, yes.
Exactly, my
Yeah.
And our position is, of course, that without treatment, which is what the sort of overall picture was before judgment, that position would indeed be irreversible. and we say that the evidence supported that. There was a point made about the respondent's review.
Sorry, respond.
I'm sorry, I'm jumping.
No.
We didn't quite catch what you...
made about the respondent's
You dropped your voice for the last word. The respondent's...
review.
Review, yeah.
Yes.
And I mean, that is, in essence, the respondent's skeleton argument before the tribunal. That's not a sort of extension of the decision-making process. And happily, we have a copy of it at page 3 of the supplementary bundle.
Do you want us to look at that?
I think it might be of assistance. So we see paragraph 1, for example, the respondent continues to deny the decision, but then in terms of what Judge Davey was saying, in terms of the lack of assistance that he had from the respondent on the point, that is at page 6 of the supplementary bundle. And on a fair reading of those paragraphs, it is clear that the respondent simply does not engage with the inability of the appellant to seek out or gain effective support from his family.
I noticed in passing that one of the issues that the Secretary of State thought was engaged was this PSG issue. See Little Roman, the heading Little Roman 2 on page 5. It just goes back to the point my Lord raised members of
Yes, that's my meeting.
yeah. Thank you.
I'm grateful. So, and then just finally, on just the completeness on the stigma social discrimination point, those who access to treatment, circumstances on return. I think my lady made a point about the 40% reference in the country expert report. With respect, we submit that that's not relevant to the nature of the issue here, because of course one has to look at the nature of treatment. Depression is an entirely different illness to a psychotic illness, and so we say that that is more about the assessment of the individual circumstances. Unless I can assist further.
Right, thank you very much. Is there anything else anybody wants to say?
No, my lord.
Well, thank you very much. We're very grateful to you all for your submissions, and to those who sit behind you who helped prepare the case. We're very grateful to the stenographer for her assistance. I hope that's worked well, Ms. Cohen, today.
I'm grateful.
We're going to reserve our judgments. In due course, we will send out a draft copy of our judgments to you for the purposes of correcting with typographical error, any typographical errors or minor factual errors. You know it's not an opportunity to re-argue any of the points in this case. Please bear in mind that the the judgment is embargoed in draft, so it mustn't be disclosed, save to the people to whom it's allowed to be disclosed. And that any breach of that would be a contempt of court. When you get our draft judgments, please will you also send a draft order reflecting our decisions. If there are any ancillary issues which remain unresolved between you, that you can't agree and put in the order, then please submit short written submissions and we will make a decision on those ancillary matters on the basis of those submissions. In due course then, the judgment will be handed down, electronically in the usual way now, without the need for any attendance. Thank you all very much.